Welcome everyone to our webinar, Zoning and Land Use Basics for Small Businesses. This is presented by the Vermont Law and Graduate School and the Vermont Small Business Development Center. We are working together through a partnership called the Community Navigator Pilot Program, which is a statewide effort to connect business owners with the tools and resources that you need to start and grow your businesses. This program is funded in part through a grant with the U.S. Small Business Administration. Before we get going today, just a few housekeeping and technical logistics. We will turn on live captioning for this. Please know that sometimes the captioning is not quite as accurate as we would like to be, as it is powered by artificial intelligence. We do ask if you have questions along the way to use the chat. And at some point toward the end, if we have time, we'll have you turn on your microphones and ask your question directly, or we will have our hosts ask your questions from the chat. So with that, I'm going to turn it over to Professor Nicole Killoran to introduce the team of presenters today.
Hi, everyone. Welcome. We are so glad that you could join us today. I am Nicole Killoran. I'm a professor at Vermont Law and Graduate School. I have here 4 of my delightful students. We have Kate Frederick, Stephanie Nam, Brian Holmes, and Mary Suttmeyer. They are with us this semester for a class called the Entrepreneurship Legal Laboratory, and they have been studying hard the topic of land use to join me for this presentation. So big thanks to them. We are going to cover a number of different topics for the webinar today, but they're all within 3 categories: town zoning, Act 250, and how neighbors can get involved in business projects. So again, this webinar is going to be targeted to small businesses for the most part. These rules apply to any particular individual or business in the state of Vermont, but we'll try to target some of the information to small businesses in particular. They are all related as well. Town zoning is local, Act 250 is at the state level, and neighbors can get involved at both levels. I'm going to hand it off to Stephanie. We're going to start with town zoning. She's going to go over the basics of town zoning. Go ahead, Stephanie.
Hi, everyone. Good to meet you. My name is Stephanie, and I'm 3L at Vermont Law and Graduate School. As you can see on the screen, I will introduce town zoning basics. Municipal town permitting is local. Each town has its own government, and towns can set their own rules for how development happens in their boundaries. This might include zoning ordinances, subdivision regulations, town plans, and access to town highway policy. And many towns divide their land into different zones or districts. Zoning rules, as known as ordinances and bylaws, regulate how land can be used and what use is permitted or prohibited. For example, what it can be used for, what can be constructed, building at lot dimensions, and related things like landscaping, parking, screening, pedestrian access, renewable energy resources, lighting, and signage. Subdivision regulations control how land is divided up. So this subdivision regulations would apply when a business divides a property into 2 or more lots. Town plans describe goals that illustrate the overall character of a community. And sometimes this is important, especially in litigation or when trying to convince the Development Review Board who grants or denies zoning permits. And access to town highways. Each town controls work in town highway right-of-way, connection or repairs to town water sewer lines or storm drains. There are limitations on what town can regulate, and they're generally where the state steps in and regulates, such as farming, forestry, electric utilities, and telecom towers. And next, we will see overview of process of getting zoning permits. So before we go into details of zoning permits, I'd like to give you a brief overview of process of getting a permit. The first thing to figure out is whether your town has zoning and subdivision rules. If it does not, you will be under Act 250. If there are zoning and subdivision rules, then this is the general process for businesses looking for a zoning permit in 5 steps. Pull up the zoning rules and check what zone you are in. Then clarify what is your proposed use and ask whether it fits the zone. If the proposed use fits, Check if it's exempted, allowed, or conditional under the rules. If the proposed use does not fit, there are some other options you can take, which we will explain later. Lastly, there will be another process you need to do when you have your permit. As we move ahead, we'll discuss this process on each step specifically. Every town has different format, but zoning rules generally have the same parts, even if they look different. They typically have definitions, zone descriptions, permitted uses, procedures to get a permit and to review projects, dimensional requirements for particular projects like building size, lot size, and setbacks. Sometimes they have special rules. We will also discuss later. Now, turning to the steps to get a permit, the first step is to identify the zone of your business. You can get the zoning map from each town's website and look for what zone your business is in. Each zone is set up by uses like agricultural, residential, or commercial uses. Once you know the zone of your business, see the uses that are permitted in your zone. Sometimes the zone might have density requirement, so lower density areas like agricultural zoning, the town might limit different uses like residential or commercial uses which involve higher density. Next, look for an overlay district. Overlay district is something the town has adopted to provide greater protection for development in sensitive areas like downtown, historic, and watershed districts. Common these days to see towns adopting a floodplain overlay to be more restrictive on what can be done in flood areas. What is the purpose of the zone? The general purpose of the zone is aspirational, but it is helpful to know in case of difficulty in getting a permit. For example, the purpose might keep low or high density, encourage commercial industrial uses, or sometimes maintaining rural character. Before you start a business or a project, look for what other businesses in that zone would be helpful. This is important because usually other businesses are going to indicate your project is permitted or not. Now, Professor Killoran will show you briefly how the zoning rules describe the uses of land.
Yeah, we're going to go through an example here. This is from the town of Randolph. And this is just one example of one zone from the town of Randolph. They have designated what is called a central business district. This is actually a pretty common designation for what you might anticipate would be the center of business in a particular town. Sometimes it's called the downtown district. Sometimes it has different names, commercial district, but there is generally going to be a central district where a lot of businesses, commercial retailers and businesses can be concentrated. In this particular example, you can see this is an example of a format. Again, every town has a different format, but zoning rules generally will have the same parts, even if they look different. So you've got here the development standards, which set out dimensional requirements for buildings or lots that are in this particular zone. Minimum lot size, width, and size per dwelling unit, the building height and coverage, and then setbacks. This being a commercial zone, there's no side or rear setbacks. There's only a 10-foot setback from the front of the property. You also can see here there are allowed uses and procedures that are described for how to get a permit and how to review projects. You can see in this table the category of use. In Randolph, they have put a lot of they've put their use categories into general, broadly defined categories. You can see how they're classified in this column, and there's a little key over here, so you can see how the town defines that particular classification and what process it's going to have to go through. And then there's this additional column if there's any additional rules or size limitations for this kind of a development. That's where those notes go. So again, you're going to look for what you see in your town zoning regulations. It may not look like this, but it will have similar information. So again, first step is to identify the zone, look for the zoning map, find out which zone you're in. There will be different zones like agricultural, downtown, residential. They're set out by use and density. Typically lower density areas are agricultural or residential. There will be different uses for different zones. Look for the overlay district, look for the purpose of the zone that's set out in the zoning regulations, and then look around at what other businesses are in that zone to get a feel for whether a business's project should be approved or not, or could be approved or not. I'm going to hand it back to Stephanie, who's going to talk about what the proposed use and how it's defined and how it fits the different zoning.
So once you have some sense of your zone, the next step is to look for a proposed use of your business. Look for the definition sections and see if there's a definition for your project you have in mind. Sometimes definitions don't exactly fit into your business. If it's a rough fit, it may be approved, or sometimes you have to get creative to make fit. Also, take a look at zoning rules, whether your use is exempted from needing a permit. Some activities do not require specific review and are exempt from permit requirements. Some activities might need administrative approval or just notice to the zoning administrator. For example, in Burlington, if you want to run a business out of your home, the zoning administrator just needs to be notified as long as you meet the requirements. Another example, some towns require a permit for building a fence, some don't. So if the zoning laws are silent about building a fence, you might want to confirm it with the zoning administrator, but it might mean you can just build a fence without a permit. In the Randolph example, garage sales can be held once a month without a permit. Temporary events like weddings, concerts, fairs can be also held up to 4 days per year without a permit. Are there any special rules that apply to your project? Sometimes the town has special rules for specific uses the town wants to control more closely. Special rules might be set out in a section that says supplemental use standards. A good example of this is accessory uses. These are uses that are incidental to the primary use, like farmstead on a property that is primarily used to grow crops. Sometimes there will be rules for types of development that the town wants, like farm complexes or senior housing. Now I will pass you over to Professor Killoran, figuring out what to do to get a permit.
Okay, so this is going to be a big part of the discussion because this is where a lot of the tricky steps come into play for businesses. Once you figure out what the rules are for your project in your zone, the next step is to figure out what happens next. How do you get a permit? There's generally a few categories of processes. The first one is a permitted use. This is a pretty easy one. This is one that usually just needs an application for a zoning permit, which is submitted to the zoning administrator. That's typically the town official who's handling these requests. The application submitted, and that's usually is going to result in a permit. Some uses are permitted in certain zones, so it makes sense that if a business has a choice of where it's going to place its place of business, if it has a choice, it might make sense to try to target a zone in that particular town that allows that use for the business. Some businesses don't have a choice, so that may not be an option. The next level of review is called site plan review. As you can imagine, this involves review of a site plan. So it looks at the dimensional and physical requirements for a particular project. Typically, it's going to involve review by the Development Review Board or the Zoning Board of Adjustment. We'll refer to those terms a few times in this presentation. I might accidentally shorten them to DRB or ZBA, just so you know I'm referring to the board that reviews zoning decisions and site plans at any particular town. Site plan review is a closer review. It looks at physical features, like I said. They may review the project for things like dimensional requirements, access for vehicles and emergency vehicles, pedestrian and road traffic, parking and loading, landscaping and screening, grading and drainage, outdoor storage and displays, lighting and signage. Those are some of the common areas that might be regulated in a site plan review or might be reviewed in a site plan review. When a business is looking at a particular set of zoning rules, it can help to look for things like site plan review criteria to figure out what is going to be reviewed during site plan review. There can sometimes be multiple site plan reviews, depending on a project. There might be an initial, there might be an interim, and there might be final plan site plan approval. Sometimes site plan approval might be needed even if a use is permitted. So using the example back here, you can see that permitted use slash site plan is designated with the P/S. So in the central business district in Randolph, the use might be permitted in an existing building, but otherwise the site plan needs to be reviewed by the DRB. Pardon me. So it can be both. There might be both kinds of review for any particular project. The next level up is conditional use review. This gets a little more tricky because it looks a little more closely at a project. Conditional use sets conditions, as the name might imply. It sets conditions to be met that must be met in order for the DRB, the Development Review Board, or the Zoning Board of Adjustment to approve a particular project. So things that a business should be aware of when they're approaching this process. There will usually be a hearing in front of the board. There's usually a set of criteria that the board is going to consider when they're setting conditions, and those criteria all center around health, safety, and community welfare. So it looks, well, we'll get to Act 250 in a little bit. It does look a little like Act 250. It's almost like mini Act 250 review. There can be criteria such as no undue adverse effect on community facilities like public sewer and water, on traffic, existing zoning rules, no undue adverse effect on renewable energy resources, no neighbor impact. This is where sort of nuisance claims come in. No dust, noise, glare, shade, vibration, or nuisances that are unusual for that zoning area. And then there's a very broad category that's sometimes thrown into zoning rules, which is that a conditional use review must determine whether the project meets the character of the area. Is it like the other buildings and uses in that area? So again, conditional use review is usually reserved for business or non-residential uses. It's usually a little closer look than site plan review. And that's why because it's a business or non-residential use, that's why it's examined a little more closely. Something to be aware of, we've referenced Act 250, we've referenced zoning rules and subdivision rules. If the town adopts both zoning and subdivision rules, then Act 250 is a little different, but something to be aware of that we'll cover later. If the town that a business is in does not have both zoning and subdivision rules, Act 250 might actually apply. Again, we'll talk about that in a little bit. A couple more types of processes here before we move on. Planned unit development. This is also what's called a PUD. This is a mixed and multiple use project, particularly suited for large or even medium-sized housing developments. These projects have to go much more extensive review typically than other projects because they usually involve some sort of mix of commercial and residential use. PUD applications can also sometimes qualify for greater design flexibility. So sometimes some less rigid standards, more open space, designed, walkable areas, and then sometimes compact residential areas with multiple housing units in the same area. And something to be aware of here, subdivision regulation is usually separate from zoning regulations. Even if yes.
You have a question in the chat.
Oh, I have a question.
Yes, from Nicole. You are Nicole.
Or no,
See,
Deborah.
you might address this later, but when do abutters enter the process? This is where I have seen applications stall, and that question is from Deborah.
Yes, we are going to address that in just a few slides, Deborah. Thank you. I know that's a big point of slowing projects down, and that's neighbors do have rights, and we'll talk about that in just a little bit. Subdivision regulation, I just want to note this is something that a business may have to navigate as well. Even if a proposed use is permitted in a particular zone, if a property is going to be divided into 2 or more parcels, there's going to need to be some sort of subdivision approval from the town. Each lot may have to meet subdivision standards, which can set out the minimum lot size, the dimensions, and then the planning board can often need to be involved in the decision as to whether to approve a subdivision, and it could go all the way up to just filing a plat with the town in the town land records. There's usually a little bit of environmental review as well with subdivision decisions. The planning board will review and just make sure that there's not going to be any impacts on environmental or safety problems in the area. And finally, waivers. This can be very, very helpful for businesses. So look for waivers in the zoning regulations. Waivers are an approval from the town to vary from the requirements of the zoning regulations, and they can be useful if a project doesn't quite fit is of a particular kind. And it's going to be different in each town. So they can be really broad. They're generally supposed to encourage certain kinds of development. A couple of examples: senior or low income housing, conservation areas, 2-lot subdivisions, small subdivisions, lot line adjustments, farm complexes. Each town is going to have different waivers that are set out to try to encourage particular kinds of development. So businesses should definitely look for those. We're going to finish up the process before we get to neighbor rights, but I just wanted to see if there's any other questions. Don't see any. Okay. What happens if the proposed use doesn't fit? If it doesn't fit the definitions in the particular zone? What happens if it doesn't look like a permit is going to be possible for a particular business or particular use? What can you do? There's a couple of options. You can ask whether this is a pre-existing non-conforming use. This is otherwise known as a grandfathered use of property, one that existed before the zoning rules were adopted, or which existed before the zoning rules changed to prohibit a particular use. Sometimes that use can be continued if it pre-existed, even though it doesn't conform with the zoning rules. The limitations are that the grandfathered use cannot have changed substantially, and it cannot have been abandoned. So for example, an old farmhouse or a building built in the 19th century that if it was built under today's zoning regulations, it would not meet the setback or the dimensional requirements. It may be possible to get a permit to build in the same exact footprint as the farmhouse if it's torn down. Generally, the rule is if something was being done before and it stopped for a while, towns are not going to allow it to start back up again. So be aware of that. But an existing building or an existing use that is going to occupy the same footprint might be possible. Next one is waivers, which we just addressed in the previous slide. Sometimes it is possible to ask the DRB or the ZBA to give a waiver for deviating from development standards. So it's pretty common. And again, a waiver is something that the review board has the ability, it has the discretion to make decisions on. So review boards can often have the discretion to decide if the setback can be reduced a little bit, or if the dimensions can be reduced a little bit. It doesn't hurt to ask. Ultimately, if a business doesn't quite fit the particular requirements of a zone and that particular lot, it cannot hurt to ask the review board for some sort of a waiver. And finally, what I think that folks should treat as a last resort is the possibility of a variance. If it's not a non-conforming grandfathered use, if you can't get a waiver, it may be possible to get a variance, but it's really, really hard. So these are really tough. Towns don't like to grant variances. A variance is something that may be appropriate for a particular use or a building that would otherwise be prohibited, and it's not grandfathered, but you're arguing that it should be allowed anyway because there's no other reasonable way to place the building or to have that use on the property. This often happens in small lots, and it often involves dimensional limitations. Again, very difficult to get. It's a tough review. You have to prove there's no other reasonable way to do what you want to do with the property, and that allowing it will not change the character of the area. And unfortunately, saying it's really super expensive to do it the way that the town wants you to is not a way to get around it. So that's a variance. The last one I want to look at, which is hopefully the great next step for businesses, is what do you do when you got your permit, right? That's great. You got your permit, wait 30 days. This is where neighbor rights are going to start to come in, Deborah. So wait 30 days. That is the appeal period for someone to appeal a granted permit to the Environmental Division for the Vermont Superior Court. Wait at least 30 days. So when representing developers, I will tell them to wait 31 days typically before they break ground. It's really important to make sure that appeal period passes. And then if it's a conditional use permit, go ahead and proceed, but make sure that the conditions are met. So there may be restrictions, for example, in a permit on what lighting has to be installed, what bushes or trees have to be put in, and different dimensional limitations. Make sure that the conditions set out in the permit are met as you proceed with the project. What happens, alternate step 5, right? What happens if the permit is denied? This is where appeal rights come in. So it is possible to appeal the decision for a denied permit if the zoning administrator denies the permit. There is a mid-level appeal to the Development Review Board or the Zoning Board of Adjustment first. And then if that fails, there can be an appeal to the Vermont Superior Court, Environmental Division. So I'm going to cover neighbor rights just to give you guys a more detailed idea of what happens if there is a problem with the permit and how neighbors get involved in town zoning. We're also going to come back to this at the end of the Act 250 part, because neighbors have participation rights in both town zoning decisions and in Act 250 decisions. They look slightly different for each one. The important thing to know here is that small businesses, your neighbors can get involved in your town zoning permits. It starts with the DRB and the ZBA. Anyone who is an interested person can appeal a permit to the board. An interested person means that typically they own property that's affected by the that's affected by the project the business has in mind. Usually it's going to be adjacent to the business's property. It also can mean someone in the immediate neighborhood who can demonstrate that there is a physical or environmental impact on them. It can also include any 10 voters in the town who sign a petition who may not be in the immediate area, but who can claim that there will be an impact on them. For example, there neighbors who claim that a particular operation is going to be super noisy and will be heard up to a mile away. 10 of those neighbors sign a petition, they might have the ability to say they're an interested person. So again, ultimately, this means that your neighbors can participate in the public hearings that take place before the DRB or the ZBA. They can, if a business gets a permit, a neighbor can appeal it to the DRB. If the neighbor is participating in the hearing, in the public hearing that's set to review a permit or for site plan review or conditional use review, they can present evidence. They can submit letters talking about the project. They can speak up at the hearing. They can present pictures. They can get involved, and they can sometimes interfere and sway the board. This is what Deborah was referring to. So when do the abutters enter the process? They have the ability to enter the process the moment that the zoning administrator grants a permit. Depending on how the board's hearing goes and how the decision comes out on the permit after that hearing, that decision can also be appealed to the Vermont Superior Court, Environmental Division. And that turns into what looks very much like a lawsuit for most towns. Whether your neighbors can get involved at the court level, this is also called the environmental courts. That's the common name for this court in Vermont. Whether your neighbors can get involved here depends on whether the neighbor participated at the town hearing. If they did participate, if they presented evidence, if they spoke, if they submitted a letter, if they submitted pictures or something else, they get notified that there's been an appeal, or they have the right to file an appeal to the court, and they have a chance to participate in the appeal throughout. This is sort of why in Vermont, NIMBYism is codified. It's not in my backyard is something that applies to a lot of Vermont neighbors. They get involved, they have the right to get involved, and they have the right to try to stop projects that are happening in their backyard. So again, something to be aware of for businesses. We're going to offer a few tips at the end here just to explain what you might do as a business to avoid neighbor challenges. But before we get there, we're going to switch over to Act 250. I'm sure a lot of you are aware of what this is. Maybe some of you have already encountered it. Hopefully you haven't, but maybe you have, and it's an interesting process. Let's put it that way. Just an overview of Act 250. It was passed in 1970 at a time when there was a lot of pressure from outside developers coming into Vermont wanting to create large-scale development. Vermonters being stubborn, they decided that they were going to create a quasi-judicial process that required that large-scale development would not have a big impact on the resources that Vermonters valued. So this includes not only natural resources, but also community and fiscal resources. And I'm going to pass over to Mary.
Sorry, somebody had just asked in the chat if there is a new slide, and it looks like there is. Thank you.
This is the new slide. Thanks, Deborah.
Thanks, Professor. So I'm going to do a brief overview of what Act 250 is and when Act 250 applies to businesses. Act 250 was designed to mitigate developmental impacts on the environment and the community. It created 9 district environmental commissions, and Act 250 evaluates the impact of large-scale developments using 10 different criteria, which will be discussed in upcoming slides by Brian. So when does Act 250 apply to businesses? There are some jurisdictional triggers to be aware of, and those are developments over 2,500 feet in elevation, commercial or industrial developments on 10 plus acres of land, subdivisions creating 10 or more lots in a 5-mile radius in 5 years, substantial change to grandfathered developments, meaning pre-1970 developments. And in towns without zoning and subdivision regulation, the triggers are commercial or industrial development on more than 1 acre or a subdivision creating 6 or more lots in the same town in 5 years. So next on the next slide.
This is what I was referring to earlier when I was talking about towns that don't have zoning and subdivision regulations. There is some potential for Act 250 to apply to business projects, to a commercial project that's on more than 1 acre. And I bring it up here to remind businesses that they should be aware of it, and also so that they know that the Natural Resources Board, which is responsible for enforcing Act 250, can and will get involved at a neighbor's request and will send an enforcement agent out to a business's property to investigate and to say, looks like you're running a business and your property's 1+ acre. You got to get a permit. So just be aware that it's out there and that neighbors can trigger that as well. Go ahead, Mary.
So on this next slide, I'm going to discuss the Act 250 process, and that can kind of be condensed down into 3 steps. The first step being contact the district coordinator. Before you do that, you'll want to collect some information about the project, such as the location of the project, the type of development, the number of lots, and the size, and lastly, the related permits. When we go through the criteria on the next slides, we'll talk about these related permits that also help. If it is unclear whether an Act 250 permit is required, a business can ask for a jurisdictional opinion. The district commission will give an up or down vote on whether the Act 250 permit is required in this jurisdictional opinion. These opinions can give some assurance to the business whether to proceed or not with Act 250. And after that, you would want to submit an Act 250 application if required, after which the application will be reviewed for completeness. So step 2 would be to undergo district commission review. And through district commission review, they can decide whether to go forward or not with the following. The 3 different types of review are administrative amendment, minor application, and major application. And I'll go through these. So administrative amendment is just an amendment to a previous permit, and this is the lowest level. It gets a bit more complicated going forward. And the next is a minor application. This is for minor projects, and this is what is decided whether it is a minor or major project is decided by the Commission Review Board. So with a minor application comes a public comment period. During this period, any person may submit written comments to the review board concerning the proposed enforcement action. The next type would be a major application. These are for major large-scale projects. And again, this is decided, what is major and what is minor is decided by the District Commission Review Board. So a major application can include a site visit, a public hearing for comment, and additional hearings if the initial hearing did not cover everything or if more information needs to be provided on the project to make a decision. And then at the end of that, the Act 250 Commission deliberates. And lastly, step 3, which is receive a decision on the Act 250 permit. So the Act 250 permit here will be issued or denied, and decisions on the permit can be appealed to the Environmental Review Board if it gets denied.
Yeah.
So I'm going to transition to Brian, who will discuss the 10 criteria that are used to evaluate large scale projects.
Yeah, and before we do that, before I hand it off to Brian, there is a question in the chat from Deborah, who's asking some really good questions today. She says she's had clients who are in the redrawn flood zones post-Irene who are being told this is now an automatic Act 250. The towns may have some authority if it's in their zoning rules to compel an Act 250 review. So I'm guessing that's where it's coming from. It doesn't happen too often, but under certain conditions, and as you can imagine, towns are more concerned about development in a flood zone. The town can sort of refer it over for an Act 250 process. So I'm guessing that's where it's come from. Is there a particular example that you might have, Deborah?
Would you like me to unmute myself?
Yes, please go ahead.
Okay, I do have an actual example. I had a client who owns a hospitality, a motel, and was looking at putting a couple of glamping sites on the river. The West River runs through their property. The West River was one of the most affected, obviously, by Irene. All of that area, the flood zones are being redrawn, the maps. And when they went to, they had put an order in to purchase these glamping platforms, because in glamping, you're not on the ground, you're usually putting some structure down. It can be movable, it's very movable. But even though it's a movable platform and could be moved in a relatively short period of time, and they had put the order in, I said, hold on, better make sure with the local zoning board that this is, the town, that this is not going to be a problem. And when they went, they said, nope, you can't. And it's now in this particular town, it's an automatic Act 250 if you're going to do anything in one of these redrawn flood zones. So seemed like a no-brainer, something that could easily be moved. I mean, if the weather was going to change, but they're being very, very cautious in these redrawn flood zones. So it's just adding a layer of complexity to something that normally might have been a whole lot easier. They they canceled the order. It was not worth the trouble. So
right. So Allie Baker asks, does the town in this example have its own flood zoning regulations, Deborah?
I think everything that I've seen so far is completely run by the redrawn flood maps. So if you're in, depending on what flood zone you're in, and what the towns are doing is they're just kind of, in a way, this is going to sound awful, but washing their hands. Sorry to use that metaphor when we're talking about flood zones, but of the problem and sort of pushing it up the ladder a little bit. Yeah. By pushing it to Act 250. That's the feeling. So
yeah, that makes sense. And I think that's probably a correct observation that the towns are essentially saying these are higher risk. We're just going to send it up to the state to do the review that needs to happen. So it can definitely interfere with business.
And we as advisors, our first step is always to people, before you buy a piece of property, sign a purchase and sale agreement, begin to look at a project, go for permit. The local zoning person is your best friend. You've got to go there first. You've got to start there. So
that is one of the several tips that Kate is going to offer at the end of the presentation. So that's an excellent one, Deborah. Thank you. You talk to your zoning administrator.
Thanks.
Very important person. I just want to note that when it comes to Act 250 review, even though the district commission makes the decision whether it's going to be a minor or a major application, there's another point where a neighbor can get involved. If a neighbor is going to involve themselves in the process, it might shift from a minor to a major application review from the district commission board. So there's a lot of different points where neighbors can get involved in this process. But we're going to hand this over to Brian, who's going to talk about the Act 250 criteria. Brian, take it away.
Hi, my name is Brian Holmes. I work for the V-Cell Clinic. Act 250 has 10 criteria. To look at those on a case-by-case basis, you need to on the day of, look at section 6086. That will give you the most up-to-date set of 10 criteria that anyone going through an Act 250, any business going through an Act 250 will need to consider.
And it's section 6086 of Title 10 of the Vermont
Okay.
statutes.
Thank you. The section uses three terms. It uses the term undue, which generally means more than necessary, exceeding what is appropriate or normal. That comes up in criteria number 1, which is an undue impact upon air and water pollution. When considering this criteria, there are various state and town regulations to consider. There are state regulations considering waste disposal, shorelines, wetlands. Wetlands will also have federal regulations to consider. Floodways will have town regulations to consider. And then there are also impacts on headwaters, water conservation, and streams that a business will need to look at when considering this criteria. The second criteria is water supply. If the available area has the water supply to be able to meet this developmental need. Section 3 deals with the term unreasonable standard. If a development or subdevelopment project will have an unreasonable impact on the local water supply, that is something that the project will need to consider when going over this criteria. Section 4 is the erosion and capacity of soil to hold water. This can sometimes involve stormwater, which is state regulated as well.
I just want to note here too that as Brian has pointed out, there are some points where the state regulates as well, and in different areas. So the state regulates Act 250, but it also has environmental permits that go through the Department of Environmental Conservation and/or Agency of Natural Resources. For those particular permits, if a business has a permit, for example, a wetland permit, a fill permit, or permission to build on a shoreline, a waste disposal permit, those permits can create what's called a rebuttable presumption that a particular Act 250 criterion has been satisfied, that there will be no undue adverse impact because there is a permit in place. So that just means that for the purposes of figuring out whether a particular business project meets the criteria, if there's a permit that fills one of those criteria, then that means it's presumed that it's okay under that particular criterion. Go ahead, Brian.
Yes. So this now has to deal with these 5 through 7 deal with unreasonable impacts on transportation, educational services, and municipal services. For transportation, there could be traffic studies that need to be conducted, and also considering the impact that transportation in general will have towards the development. For educational services, consult with towns on proximity to schools, see how this type of project will have an impact on the stress of the local community. For municipal services, this could include areas such as wastewater and water supply that the project will need to communicate with the municipal service in order to understand how much of an impact their project will have on and cause stress on the local environment. For Section 8, aesthetics, scenery, and national beauty, it uses this undue adverse standard, which generally means that more than necessary that causes an unfavorable or hostile to this criteria. Some parts of this criteria will involve the ANR, especially for wildlife habitat, natural areas. This criteria includes areas such as historic sites that involve archaeology, rare and irreplaceable natural areas, so that ANR might participate, and additionally necessary wildlife habitats.
Okay, and then we've got a few others that are sort of catch-alls to specific criteria, right?
Yeah, some of these areas are already regulated by the state, such as agricultural use, earth resources, and public utilities. Some are not, such as the impact of growth and settlement of particular rural areas and rural growth. So a company looking at this criteria would want to look at the undue impact upon primary agricultural soil, the production of forest soils, earth resources and the extraction of those earth resources, energy conservation within the area, as well as the private utility services, the cost of scattered development, and various settlement patterns, formerly known as rural growth areas. Additionally, local and regional plans will need to be taken into consideration. This criteria looks at whether a particular project fits the goals of the local and regional plans as a whole.
Yeah, so coming back to the discussion about the different ways that towns can regulate different property uses that Stephanie touched on at the beginning, there is typically going to be a town plan and possibly a regional development plan. These are aspirational documents. These are documents that the town or the regional planning commission put together to say, this is what this town or the towns in this region envision for the future of this area. These are the kinds of development patterns and or settlement patterns that we want to see. These are the kind of uses and property uses that we want to see in this particular area. So those are aspirational, but under Act 250, they can have quite a bit of sway in determining whether a project meets the criteria. Deborah has another comment. I've also had the State Historical Society stop a project in the Act 250 process. That's the one. Yeah, you're right. It's in number 8, Deborah. Or does it matter? So I assume by saying or doesn't matter is like, there's a lot of different ways that these different criteria can get involved and slow down a project, right? This can be pretty onerous. It can be expensive. There is a permit fee that applies when a business applies to construct a project. And depending on how many thousands of dollars the project is going to cost, there is a percentage, a particular fee attached to that per $1,000 of construction costs up to a limit. So there's a fee as well for an Act 250 permit. We're going to go on and Kate's going to talk about what it looks like for neighbors to participate in a Act 250 process. And then we're going to have a couple of tips that Kate's going to offer for ways that businesses can try to prevent neighbor problems.
Thank you, Professor. Hi, everybody. Good afternoon. My name is Kate Frederick. I'm a third-year law student and very interested in land use law. Regarding neighbor rights, they're not automatic, so you want to check on that. You have to apply for what's called party status per issue that or criteria that that a neighbor may have a concern with. You can only participate in the Act 250 process if you are granted party status and only per issue or criteria that is granted. So we're going to do a quick look at the statute, or I'll speak about that quickly. The key word in the statute is particularized interest. So it basically says any person who has a particularized interest protected by this chapter that may be affected by an act or decision by a district commission shall be entitled to party status. So what does that mean? Your interest in the project must be particular to you rather than the general public. So the interest must be real, not speculative. Can you see? Can you hear it? Can you smell it? Does it affect an activity that you're involved in, or does it affect your actual property? So not covered under Act 250 for neighbor rights is whether or not this new project would affect your own business and create business competition. That is not covered under Act 250 for neighbor rights. Another concern that neighbors often have is that this new project will lower their property values. That is not covered under Act 250 as well. So in terms of tips for neighbors, good fences make good neighbors, but have a conversation over the fence. So what you want to do is talk to your neighbors even before you apply for the Act 250 permit. or status, and let them know what your plans are and see if they have any concerns. You can put in your plan how to mitigate those concerns, and you can discuss them with your neighbor and see if that wins them over. It's just good business sense to do that in general, especially if you're in a small town. For example, my plow guy, whenever I have to call him to say, are you coming? Can you stand? I have to get to school. It's his wife that answers the phone, and she's a leader in the town. So if I ever need to apply for a permit, that's who I go to. So you want to be aware of your relationships in the town with your neighbors.
Another good place to consult with your neighbors, the general store. That's a great place. The places where people are gathering and chatting, if it's not over the fence, then it's somewhere where you're going to get coffee, or it's your, if you have a town large enough to have a business or a coffee shop, something like that. The library, that's a great place too, right? Any place where neighbors or folks who might be concerned might gather is a good place to go to discuss the potential impacts and whether anybody has any concerns. Go ahead, Kate.
So the other thing I wanted to mention is not every level of the process creates the need for a hearing. So if you're a neighbor and you have a concern, you may need to request a hearing to be heard. Let's see. What else did I need to cover there, Professor?
I think you pretty much covered it. I wanted to point out a few things, which is that so these are rights that neighbors to a business have. So business is well advised to talk to their neighbors, but these are also rights that a business has to neighbors as well. So if a neighbor has a project that's going to be developed and a particular business sees that it might interfere with their company or with the way that they do business, that business also has a right to participate in the town or the state level to possibly appeal a decision if they can show that they have an interest or that something's going to be impacted. Again, business competition is, as Kate said, and lowered property values, that's not enough to say there's going to be a particularized impact. But the point is, even if your business anticipates that a project is going to suffer in some way, if that impact is covered under one of the Act 250 criteria, that business might be able to have party status on that criterion, and that business might be able to participate in the proceedings. I also wanted to note that there is an appeal process for Act 250 decisions as well. There's some limitations on folks' ability to participate in those hearings. So the those appeals will generally go from the district commission level up to the environmental court, to the environmental division. Neighbors who were granted party status at the district commission level, just like neighbors have the ability to participate in an appeal in the environmental court if they participated in the town hearing, neighbors in an Act 250 permit have the right to participate in an environmental court appeal if they participated at the Act 250 district commission level. So it's parallel rights, but it is more limited. The town is broader. A neighbor can show up to a town hearing for a permit and complain about the project, and then they get to participate in the appeal to the environmental court. But a neighbor has to show that their particular property or their particular interest is going to be impacted by one of the Act 250 criteria in order to participate at that level and in an appeal that goes from that permit. So it is a little bit different, but really the message is talk to your neighbors. If there's concerns that need to be addressed, it might be a matter of redesigning something, adding some screening. A common concern that I see raised is, I don't want to look at this project. I don't want to look at this wedding venue. I don't want people to, I don't want there to be music at all hours. I don't want to have to look at the lights that are going to shine into my window. A lot of it is aesthetic impact. And there are ways to deal with aesthetic impact that a business who's proposing a project can address before they even get to the point of requesting a permit. And the more that neighbors' concerns can be addressed in advance, the more likely the project is going to have a smooth sail. That said, it's always possible that there's going to be a neighbor who's a NIMBY who doesn't want a project in their backyard. And those are difficult to deal with. thing I would recommend businesses to take away from that is just that there are rights, that there are limitations on a neighbor's ability to complain about a project, that they have to show that at least there's a particular reason to complain about a project. It can't just be, I don't want this in my backyard. So that's the conclusion of our presentation. We'd love to take any questions if anyone has them. I don't see any in the chat right now, but we'll wait for a minute. Cost for an Act 250. I'll look it up really quickly, Deborah, but it's like, it's a particular amount per $1,000 of construction costs. If any of my students have that handy, I'd love them to pipe up. And when do you hire an Act 250 consultant? Go ahead.
I was going to ask the question while you were looking up the number.
Oh. $6.65 per $1,000 of construction costs. And there is a cap on that. It only goes up to, let's see. It only goes up to 15 million in construction costs. So obviously the large, like basically every construction project in the state fits within those boundaries, except for the larger ones. So that makes sense. When do you hire an Act 250 consultant? Here's another tip for businesses. Find a good engineer. Engineers are more often than attorneys. Engineers are the ones who are supporting businesses at the town level or the Act 250 level when they're requesting permits. They're the ones who are designing the site plans. They're the ones who are pointing out what the engineers can actually do a pretty good job of reading the zoning regulations and the Act 250 requirements. And they often have a lot of experience in walking businesses through this process and can offer some really good advice. There are such things as Act 250 consultants. They're the ones who have a lot of experience specifically with Act 250. I would say that if a business has the ability to at least consult with one, the earlier the better. How long is a typical Act 250 process? I'll stick with that one, then I'll go back to the town question. That depends on who gets involved. So if the neighbors get involved, if they decide to make a stink, if they have some concerns that someone could not address before the permit was applied for, it can take a long time, and it can go through litigation and then go through an appeal and sometimes go back down to the environmental court. It can take a long time. There again, more reason to try to talk to neighbors and see if there's some sort of resolution that can be reached. Sometimes projects just have to go through the expense and cost of going up and down through the courts because sometimes neighbors are just not going to say okay. But in my experience, at least, neighbors like to be consulted and they like to be included in the process. Are variances or waivers to zoning permits public records? And if so, where could I go to see them? They are, because they have to be granted on the public record and they're recorded in the land records. So if a particular permit included a variance or a waiver, that would be recorded theoretically in the permit, and the permit would be recorded in the land records. Until about 1995, towns did not record zoning decisions. Since 1995, there was a decision that came down from the Vermont Supreme Court that said that if a town does not record a zoning decision, that it has a very short enforcement time. So towns now are recording their zoning decisions in the land records.
And Professor, is it true? I'm not positive. I'm not like asking a leading question, but don't some towns not have their records on electronic files, so you have to physically go look up the records? Yeah.
I don't know what it is now because I haven't done a land use search in a couple of years. I haven't done real estate work, but when I did that last about 5 years ago, most of the towns were not on electronic records. Maybe a few more of them are now. But in order to do a search of the land records, it's almost guaranteed that someone's going to have to go to the town office and look. And sometimes the land records are in really interesting places like boiler rooms or back offices of someone's home or these dank little dusty basements. It's different for every town, just like the zoning rules are different for every town.
I've seen towns also that do have some information up on their website, but the records are outdated. So even their application isn't the current application that's up there.
Yep.
So maybe it's a good idea to follow up with a phone call, even if you think you found the right information.
Yeah, and as Deborah said earlier, keep in touch with your zoning administrator. That's a very important person for any business to be in touch with. Talk to the select board, talk to the members of the board, talk to the zoning administrator. It's better to take these steps first than to be surprised when you apply for a permit. Deborah asked about the shortest process. She said she'd had a couple that were 2 years and a couple that were businesses that simply walked away. Prohibitively expensive and very emotional. Yes, and that is one reason why development, whether it's housing development or business development in this state, is very difficult to come by. It's extremely expensive, and Act 250 is one of the reasons why it's so expensive. It limits development. It was intended to limit development. So it is actually accomplishing the original purpose from 1970. And as everyone is probably aware, nearly every legislative session, there is some proposal to revise Act 250, or there is some item on the ballot, not necessarily on the ballot, but on a politician's agenda, especially during re-election time, that says we need to reform Act 250. And there is a lot of room for reform. This is a set of regulations that also reflects Vermonters. This is what Vermont wanted. We like our quaint little villages, and we like our controlled development, and we like our trees and our screening. It also means that along with that, we restrict business growth, and we restrict jobs, and we restrict our young people's ability to find a job and to stick around. So there's lots of different things, lots of different dimensions to this. Deborah says she has a town that has no local zoning requirements, so all commercial ventures trigger an Act 250 only if they are on over 1 acre. Deborah. So it's commercial or industrial development in a town with no zoning or subdivision. The trigger is not a 10-acre property, it is a 1 acre property. Or if there's a subdivision of 6 or more lots. Okay, any other questions? All right, take it away, Sarah.
Thank you. And I want to close by thanking Nicole, Kate, Mary, Stephanie, and Brian. We appreciate you and your contributions to the Community Navigator pilot program that is lifting up Vermont businesses. I also want to thank everybody who attended with us today and who are joining us for the replay. I encourage you to reach out to us. I dropped a link in the chat. We'll also put it in the show notes, or you can scan the QR code on your screen to connect with the Community Navigator pilot program. Connecting with any one of our partner organizations connects with all of us to provide you with the resources that you need. We also encourage you to visit that website to see any upcoming webinars and to sign up for our newsletters so that you stay in touch and get the most updated information. So until next time, we want to thank everyone and have a great day.